Welcome to the Truvantis Risk Radar. Our guest today is Jerrod Montoya, an attorney and expert in privacy, governance, risk, and compliance. I spoke with him about how healthcare technology vendors can manage risk in the face of the rapidly evolving landscape of information privacy legislation. So, Jerrod, given that privacy laws are constantly changing, most clients are subject to multiple jurisdictions. Risk management is poorly defined in the law, and most, if not all, of the new privacy laws are yet to be litigated. Specifically for corporate leaders at healthcare technology companies who are accountable for their information privacy but not responsible for the day to day task, how do they know they have the correct processes in place?
Well, really, the challenge for any leader is to understand what is going on in the industry, especially when a situation arises where you have rapidly expanding laws and rapidly changing laws for those that are newer. In the health tech sector, there's a tendency from history to say, oh, okay, well, if we're dealing with data privacy, it's only HIPAA, and HIPAA only applies to certain segments of the industry. Perhaps there was a prior legal analysis that said, hey, HIPAA doesn't apply to us, this little niche area that we're in, or for whatever reason. And the reality is the landscape has changed a lot just in the recent past few years. Um, for example, the FTC is upticking enforcement for deceptive practices based on handling of personal information and under the breach notification rule that they have. But more importantly, state laws have evolved to a point where they're filling a gap that previously existed, where even if it's not HIPAA, the state laws are applying to personally identifiable information, especially sensitive information that relates to health information. And with the fact, combining that with the fact that the health information in the black market that we know is very valuable. And so for health tech leaders, if you haven't looked at this within the last year or 6 months, you're probably behind the eight ball. So how do you know? It's that it's in your face, and if it's not in your face today, then you're probably behind.
Okay, but if I'm the general manager of a division or maybe the CEO of a health tech startup, and I'm aware of what you said, I know I need to be compliant with the laws. Maybe I'm not a lawyer nor a technologist. How do I know what to tell someone to do? And how do I get that peace of mind to know that I'm properly covered?
The peace of mind is that you understand the risk environment as the as stepping stone. So on the one hand, you're getting constant reports about what the status is of your program as it relates to protection of the sensitive information. What is the risk to that information? If you're not getting that, then that's a key flag. To the next step in the process, you can look at more of a continuous monitoring of your program as a whole. What are the issues and the deficiencies that are being found, and are they being resolved? More recently, there's been a trend pointing towards potentially using common frameworks, which is an evolving area. It's very immature, but there is an existing framework from NIST, the National Institute of Standards and Technology. They have a privacy framework that works alongside the NIST cybersecurity framework. And that is one option, is to look at that and benchmark off of the framework to see how mature the processes are internally. Um, from a security standpoint, from the protection side of the equation, you can look at other common frameworks that are more ubiquitous in the information security space. So the more common frameworks in the information security frameworks would be like a CIS controls framework or ISO or a NIST 853, SOC 2. These are other ways that you can get assurance that you have sound practices around the protection of sensitive information. But the reality is, I think you have to understand your business process first, understand the risk that's being posed by the handling and processing of that uh, sensitive information that you have. and then look to the case law as well. So from a legal standpoint, looking at what the FTC is doing, for example, in the case of Flow Health, GoodRx, how they're approaching these health tech companies and what they're requiring them to do on the back end, you can see if there's any parallels to how your business is operating and learn from those cases and those business practices as examples of how well you're doing or how significant the risk is posing to the organization.
You mentioned the NIST privacy framework. Are the laws today beginning to mention the NIST privacy framework or other industry frameworks in terms of guidelines?
So some laws are starting to point to common frameworks, and really they're looking at an example of how you can demonstrate compliance with what they see as best practices in protecting information or handling personally identifiable information. The NIST privacy framework has been around for a few years, and it's actually going through an update. But that's less common today than something, say, the NIST cybersecurity framework, which has gained more traction in the industry. Alongside CIS controls, there's actual legislation that says specifically that you can demonstrate compliance through those mechanisms. But over time, this is going to continue to evolve and take shape. And really, you're looking at trying to stay abreast. And so, if you unpack these frameworks, and really they're saying a lot of the same things, and it's about understanding your risk posture, applying controls based off of your risk posture, and constantly reviewing and having a feedback of, are we doing the right thing? What's the new risk today? Okay, are we managing it? And where companies get into trouble is when they do like a process where they just implement something and then just let it ride. Say, okay, well, we did it once, we're good. And it has to be a continuous process of improvement and management and care and feeding, so to speak, to make sure that you're up to date with the latest best practices and that you're constantly mitigating risk for the organization.
Okay, interesting. Yes, I've heard this term of continuous monitoring talked about a lot across both security and privacy frameworks and discussions. Is that a new thing? Continuous monitoring
Correct. Yeah.
versus doing a spot check?
So you want to have a process that makes sure that you're intaking information. It might be threat information, it might be business changes, it might be personnel changes. Whatever it is, you consider how that's going to impact. And there's language out there in all these laws that you hear about impact assessment. How's that going to impact the protection of that personal information? How's it going to impact the rights of the consumers that they have within these data privacy laws as far as notice and consent? You have to consider that on an ongoing basis, and some of the state AGs are actually requesting that information. And on the horizon, for example, in California, there's going to be a process coming out where you're going to do a security risk assessment, protection assessment, if you will. And this is just in the United States. And a lot of this stuff, if there's international data that's involved, then you're dealing with GDPR and the European Union. So, this concept of constantly staying abreast of the latest changes and in the risk profile for the organization, it has to be part of that same conversation that you're having, whether you're going into a new industry or new market, or if there's a new product that's being developed, it needs to be integrated and considered as part of that same process.
Below the board of directors, who in an enterprise should be accountable for information privacy policies and practices? And if, for example, the general counsel is accountable, but the IT team is responsible for implementation, how or should the day to day interaction work between those two very different entities?
It depends. So it depends on the organization's own setup. and the size and the complexity, but how decisions are made. The fact is, you should have somebody, and if you're capable of having a designated role in, say, a chief privacy officer position or a privacy specific position, yes, that's ideal. There is a lot of legal crossover, so having a GC or a legal component, no matter where it's housed, is very important. I think the key at the end of the day is that there's some key pillars to data protection and data privacy that you need to take into account when making decisions and have that input wherever it comes from. And that's, just the personnel rights and management and what they have available to them under law. That could be a privacy person that's focused on the implementation side with a legal counsel supporting. But there's also a key component for information security that triggers more of an IT background and how you actually apply protection controls to the same information. And all these need to work together. And so, depending on the makeup of the organization, you want to look at see who do you point to for this information. If you don't have inside counsel and you have to go and you have to pay a ton of money to get your outside counsel's advice, perhaps you bring somebody in that at least can, have the capacity to understand at a basic level enough information to understand the laws to get you to a point where you have more targeted questions to legal counsel. And there's a lot of privacy professionals out there today that can fill that void. There's a lot of third party organizations, like a company like Truvantis that can do the same. And then the information security side, most organizations today have that contingent there. Maybe they're not versed on the data privacy aspects, and so you'll need somebody to bridge that gap. But having the two teams talk together and understand what the purpose is, and that's protecting that information, is the key to consider. And so, as far as a specific setup and roles of who needs to be what, there's no set guide or rule on how to do that. The most important thing is that you have the competencies in place to properly manage and understand the landscape of what's going on in the industry and how it's affecting your organization and what you're going to do about it.
When we talk to large hospitals and clinics, we often talk about vendor risk management and how they should do that. On the flip side, from the perspective of the technology vendor, how do they manage client risk? And by that, I mean, a hospital is a rich, complex environment with hundreds of integrated vendor systems. Some people would argue that hospital environments are inherently insecure to begin with. And when a breach or an event occurs, there's often finger pointing over which vendor caused the problem. Especially for a technology startup, how can they protect themselves from either admin user error or other vendors in the ecosystem?
If you go into it looking to cover your tail, so to speak, I think it's the wrong approach. Really, the right approach is not to assume that hospitals are inherently insecure because while they have their challenges, it's a unique environment. And for the most part, a lot of them that I've been involved with are actually doing a pretty good job. There's always room for improvement, I think, in most organizations. So just as a baseline, I think those are two key considerations. But when you approach it as a smaller vendor into a larger organization, you want to approach it like a partnership and understand that you're providing a key service and being a key component of that other organization. And so when it comes to detecting and monitoring and managing threats, having the a clear line of responsibility established, clear communication channels that are ongoing from a support perspective is really important. There's a tendency for larger vendors to come in and offer support contracts, and if you don't offer it, then they're just saying, okay, well, you have an unsupported product that's providing a critical care service, and that's on you, which really isn't helpful to anyone, including the patient's data that's at risk in that situation. So it's all about how you structure things coming in and being transparent and working with the other organization. As far as supporting your product, making sure that you're providing patches, and that's accounted for from the get-go and as part of the service that you're providing. And that communication about if there's an incident, incident management and breach notification. I mentioned earlier about the FTC and looking to expand its breach notification rule. That works coincides with HIPAA violation requirements and notifications. So the complexity and as it continues to grow, it's really important to maintain that good relationship and have a key point of contact and be in a line as far as how you're going to manage and respond to incidents. I think those are the key aspects to look for and how to protect yourself going into that environment. To the extent that you have downstream services, vendor management on that end is really important as well. Because if you have to go to a service provider as a once removed service, uh, being able to get quick responses and to be engaged in that exercise is really important. So one way to test this out is to run through tabletop exercises and actually go through the motions of engaging these parties and pick up the phone and call them and see, are you going to get a response? How are they going to react to this situation? Oftentimes the proof is in the pudding, like you can have it all written down and there's this fantastic plan, but when you put it into operation, sometimes that story changes. So I think that's how I would, in my opinion, manage that situation. I think as a final thought, it's really important for health tech and just the health industry as a whole to understand, the direction of where things are going. You have rapidly changing legal environment combined with increased federal regulatory enforcement combined with just a natural trend towards moving towards a more technology forward managed care service. So for example, hospitals are moving into wearables that they're sending home with people to collect key information and to have more of this remote style of monitoring glucose levels or whatever. But these wearables are a new aspect of the healthcare system. You're not just going in and sitting there and having to monitor everything, you're transferring this data remotely. And so as the convenience factor rises, the security considerations have to move along with it. I think history has shown that generally that's not the case, and most likely is not the case today. But as a health tech provider, just because it's not being asked today doesn't mean that it's going to be a big consideration tomorrow. And to have it integrated from day one, knowing the tendency of looking at the past of where this is going, it's going to catch up eventually. And it's not far behind where the regulatory space is and the legal components. So getting out in front of that and baking it into the product today and having advanced capabilities is really going to do something to put you at the forefront of protecting this information, being prepared to withstand the rapid changes in the future. And we're talking about, especially in the post Dobbs era, where there's concern about using this data collected on mobile devices and wearables and just location data as it relates to abortions in this particular context has really highlighted the concern. And that's part of the drive towards really, if you look at proposed legislation at the federal level, a lot of it's surrounding health data for this reason. They're afraid that people are going to be targeted and that their, potential health issues could not be addressed. But the whole game has changed since that decision, and it's really driving a lot of things that we're seeing from the FTC enforcement actions and future legislation, and that's working together with already in motion efforts to protect personally identifiable information as a whole in places like California and now Virginia, and there's about 10 different states that have state specific privacy laws, and so this is just all continuing to evolve. And there's might be data that's collected that seems like it's not a big deal right now, and it's not particularly regulated. But just a minor tweak in the political landscape, even, and you could see how then it becomes a big factor. Think back to Cambridge Analytica and how this information was used and influencing voting. Now it's how location data is being used to influence abortions. So it's continuously evolving space, and so really the key is um, understanding the information that's being collected, understanding how you're using it, where it's going, and then having the ability to manage the communication of how you're influencing and enacting the rights that certain individuals have and being prepared for those future changes.
Well, Jerrod, it's always enlightening for me every time I talk to you. Thank you very much for being here, and we'll see you again soon.